Okay, this is four voice. We're gonna identify for you, and this is a short and fast, 5 minutes. I am Mr. Bauer for the plaintiff.
I am the witness.
I am the court,
I am attorney for defense, Ms. Parisi.
and it's a court for the record. Calling the matter People versus Thomas Hale. Mr. Hale is present with counsel. Ms. Linda Parisi, people are present and represented by Charles Bauer. This matter is on calendar for preliminary hearing, complaint number 89F01698, charging violation of section 666 of the Penal Code. Ms. Parisi, you waive full reading of that complaint?
Yes,
People are ready to proceed.
People are ready, Your Honor.
Defense ready.
we would move to exclude all prospective witnesses until called.
All witnesses remain outside of the courtroom during the course of the hearing. You are ordered not to discuss your testimony with any of the other witnesses during the course of this hearing. Mr. Bauer, call your first witness. Please raise your right hand. Do you solemnly swear the testimony you are about to give and the cause now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please be seated. When seated, please state your full name and spell your last name.
Christina Hadzicki, Hadzicki.
Thank you. Please proceed.
Ms. Hadzicki, what is your address?
2380 Oro Boulevard, number 85, Sacramento, California, 95825.
And where are you now employed?
Macy's, Sacramento,
And that's located where?
400 K Street.
And were you so employed on March 8th last year?
I was
What capacity?
security agent.
What are the nature of your duties as a security agent?
I work undercover and I surveil shoppers that are suspected shoplifters.
And were you doing this at 2:50 p.m. on March 8th of that year?
I was.
And at that time, where were you located within the store?
I was located in the jewelry
And
department.
why were you in the jewelry department?
I was called there by a sales associate on a suspected shoplifter.
I am going to object as hearsay.
The question and the answer will be stricken as not being relevant. The objection is sustained. The answer stricken.
When you got to the jewelry department, did you see any person who was acting suspiciously?
Object leading.
You may answer that one.
I was observing a subject that was already wearing one of our garments that had a Sensormatic tag on it. So to me, that was suspicious.
Do you see that person in the courtroom today?
Yes, I do.
Would you identify that person by what the person is wearing and where the person is located?
Near the defense attorney wearing the gray t-shirt.
To whom did you point?
The gentleman in the gray shirt.
The record will reflect the witness has identified the defendant.
Thank you, Your Honor. After you observed this person wearing the shirt with the Sensormatic on it, what did you do?
I surveilled him, and do you want me to go into more detail what he did?
Exactly. At what point did you start surveilling him?
As soon as I was notified, he was wearing our garment and he was still looking and
Object as to hearsay as to what he was notified.
The last part of the answer will be stricken.
What did you observe him to do
what did I observe him to do?
after the time you first sighted him?
There was this display table in the middle of an aisleway, and there were a lot of sale dress shirts all folded and inside plastic wrappings. He took off the shirt he was wearing that was Macy's merchandise and took another shirt inside the plastic wrappings, unwrapped it, the plastic, the pins, and put that on. So therefore, I knew it was our merchandise.
When you observed this, can you estimate about how far from the defendant you were?
Probably from here to the door.
The record will reflect a distance of approximately 48 feet.
Could you see him clearly?
Very clearly.
And after you observed him put that shirt on, what did you see him do next?
He then turned and walked toward another men's department where at this time, I had already witnessed something I thought was suspicious, and I called another agent to assist me. We both followed him over to the men's department where he selected another t-shirt.
At that time, did you make an attempt to apprehend him?
Never apprehended him.
When you saw him select the t-shirt, after you saw him select the t-shirt, what did you see him do next?
He then stuffed it down his pants.
Do you recall how far away you were from him when you saw him do that?
Probably about 20 feet.
And after you saw him stuff the t-shirt down his pants, what did you see the defendant do next?
He then left that department and went to another men's department where he selected a white sweater. It was on a mannequin.
I'm sorry, a what?
It was on a mannequin top, but it was on a table. He took off that and put it over the other shirt I watched him put on earlier.
Up until this time, had you seen the defendant at any time attempt to pay for this merchandise?
No, I did not.
What did you see the defendant do at this time?
At this time, he then tried to exit the 5th Street exit where the merchandise he was wearing, there were Sensormatics that were attached to it, and he tried to leave the exit, and our Sensormatic alarms went off, and it discouraged him from leaving the store. So he turned around and headed for a K Street Mall exit.
When he headed for the K Street Mall exit, did you go directly outside?
No, he slowly was looking at other merchandise, and by this time, there were other agents that were involved in the surveillance, and I was located in the women's shoe department, and another agent, my boss, had witnessed him select a pair of our sunglasses.
Object outside of her personal knowledge, ask it be stricken.
The testimony concerning the sunglasses will be stricken at this point in time.
After you saw him move toward the K Street Mall exit, did you see him at any time with the pair of sunglasses on?
Yes, I did. He was wearing them.
And prior to that time, the times you have so far described when you were following him around the store, did he have any sunglasses on?
No, what I was trying to refer to was my boss,
You don't have to refer to it.
even if he had taken them.
That's correct.
Sorry.
Next time you saw him was when he had the sunglasses on?
Yes.
Okay, that was 5 minutes at 2:20. So if it felt fast, it was. That's one. Okay.
You should embarrass
Checking to see if anything's swimming.
Oh, but you can see him. Can you see him?
No, I don't think
I
so.
think you have to look
Oh,
at
you
him
can't?
microscope.
No, I don't think so.
Who are you looking for?
Parasites.
Hmm.
You know, Judy brought up on her Facebook, there is a thing that Dasani water is, they have parasites in their water, and so they're recalling.
Yeah, you won't be seeing those guys.
No, they're microscopic.
They,
Oh, they're small? Oh, I thought
Yeah.
they were.
it looked like a jellyfish, sort of.
With eyeballs.
Okay, this is going to be practice a little bit, and then I have a couple of takes, one of which is a CSR. So we have Mr. Wall for the plaintiff, Mr. Shuckman for defense, court and witness. And this is a drug case. I am Mr. Wall for the plaintiff.
I am the witness.
I am the court.
I'm attorney for defense, Mr. Shuckman.
Let's do this in 15s. Okay, we'll read this at 200.
So this still warm up.
Still warm up. On the record with a question by Mr. Wall. Ready? What topics did you study in this formal education?
Several varied subjects. We did study heroin addiction marks. I've seen slides of different ages of marks during these schools. The school was put on, like I said, by the State Bureau of Narcotics and a doctor. We've seen what puncture wounds look like, how they're administered as opposed to a sterile, the expression medically administered injection wounds, how they differ in color, cleanliness of the wound, cleanliness of the individual. It all goes into what to look for basically when you're dealing with a suspected heroin addict.
What other topics did you discuss? You discussed marks apparently. What else did you discuss?
Well, of course, hand in hand with marks and pupillary reaction, what to look for, how to look for it.
That's an opinion. I am going to object to that as opinion.
Overruled.
Please proceed.
Marks and I findings are hand in hand is not an opinion.
Excuse me, are you objecting or arguing?
I'm sorry, I was arguing. I actually wasn't sure the court understood my objection.
I did.
All right.
First you had marks school, then you apparently studied pupillary reactions.
This was done during the same schooling and during conversations with doctors who I had called in during examinations for their opinion and basically what you call on-the-job training.
At the time of this arrest back in April 23 of 2007, what was your duty with the Stockton Police Department?
I was assigned to the heroin impact team.
And could you describe your duties with the heroin impact team?
It was an attempt to control the street heroin addicts
How did you do that?
by arresting them.
I think we have a fine comment on the state of society. I really do. That's terrific. That's just about as far as he thinks he has done.
I would object and ask the court to tell him to quit the sarcastic remarks.
I don't think it's sarcastic. I will leave it in on the record. I don't think we have found the answer.
I don't think we have either, Your Honor. What type of job experience did your duties entail?
Well,
I don't understand that question. Objection as unintelligible.
I'm going to sustain the objection. Please rephrase the question.
Were you involved with personal examinations of people?
yes, I was.
Approximately how many of these have you done?
Hundreds. You want a ballpark figure? It's hard.
I'd like to make the same objection. We're getting into the practical experience once again, the same as we did with Officer Armstrong. We have the same issue. We have had the records destroyed, so we can't find all the times. He was dead wrong, although we have at least something. I just happened to come across that was attached to the points and authorities.
Excuse me, counsel. I'm not going to argue with you, but I also find they can be dead wrong in the laboratory according to Officer Fry's affidavit.
He'll be in here. We'll talk to him.
So we don't know whether it was Fry's mistake or his mistake.
In other words, you have had experience in examining people's eyes and arms?
The objection is the same, since we are not able to cross-examine on the quality of his experience and his degree of accuracy for him to make self-serving statements. Since he has examined a lot of people and knows whether or not they are addicted or not.
Same objection. It will be a continuing objection.
Thank you.
Same court's ruling.
Have you testified as an expert in trials involving Section 11550 of the Health and Safety Code?
Irrelevant.
Sustain.
We are not trying to establish him as an expert.
Going back to your examination of Mr. Holloway, what did the examination consist of?
You want me to start telling you step by step?
Yes, please.
It was a well-lit room. I measured his pupils with a pupilometer.
What's that?
It's a small, heavy cardboard material which has a calibrated eye, pupil size. I believe it starts at 1.0 millimeters and it's broken down to 0.5 millimeters, like 1.5 to, I believe, down to 7 millimeters.
And what did you do with that instrument?
I placed it up on the side of his face and moved it up until I found the right size of his pupils that coincided with the paper.
What was the result of this procedure?
I believe it was 2.5 millimeters.
And what did you do next?
Then I completely extinguished all lights in the room and it was extremely dark. I allowed 20 to 30 seconds to elapse. Then I moved a flashlight from the outer spectrum of his face, so just the outer edge of the beam of light came in contact with his face, so therefore I could see his eyes, and I again measured his pupils. Then I moved the light into his pupils to see if they reacted to any type of light source.
What was the result of this?
I couldn't detect any movement of his pupils.
That's in the light and in the dark.
That's correct.
Was there an opportunity to tell how quickly the pupils reacted in these tests?
They didn't react at all.
What did you do next?
Well, then I turned the lights back on and I looked at his arms through what we call a mark sight, which is a circular magnification device on the end of, I believe it's a 2-cell flashlight. So you have a bulb of light within the magnification aspect and you turn the flashlight on and you have a 7-power magnification with a light attached to it, and you can place it over their arms and look at the wounds.
What did you do with this apparatus?
First, I looked at his arms and then I observed some wounds in the inner folds of his right elbow, and then they were contained in 2 sites within the inner fold, and I placed the light over each site.
And what did you observe?
Well, I believe there was a total of 15 injection wounds.
Objection. Characterization of the wounds calls for opinion. Conclusion by this witness.
Strike the word injection and allowing the remaining to state. 15 wounds.
15 wounds?
Yes, sir.
Officer, I'm going to show you People's Exhibit for identification number 1 and 2. Do you recognize these photographs in People's Exhibit 1?
Yeah, this is a photograph I took of the defendant's right arm.
And what is the photograph number 2?
It's another picture I took of the same arm, a different location adjacent to the first one.
I see. And do these truly and fairly represent the condition of the defendant's arm at the time you examined him on April 23rd?
Not really. First of all, you have to understand that when you take a picture, you're looking straight down. You can't see any swelling. There is just a 2-power magnification. You can't see it as well as you can with 7-power. But of the sites I took a picture of, I guess that's a representation.
Could you please, in detail, describe the condition of the wounds?
Well, People's number 1, it contains, I believe, which would be the second photograph I took, contains about 10 wounds, excuse me.
You're excused.
9 of these wounds appear to have a scab formation on them. However, one of them appears to be scabless. The wounds, several of the wounds are raised or appear to be raised in this picture. They're discolored, pink colored, and that's about all.
Could you describe the wounds in People's Exhibit number 2?
Well, these are contained in a track. There appears to be 5 wounds, and all 5 of them appear to be scabbed. At least 3 of the wounds are also discolored pink.
Excuse me, I didn't hear you.
are discolored pink and appear to be slightly swollen and raised.
Have you seen wounds similar to these before?
Yes, many times.
Have you had persons who were known to you to be heroin users and who have recently used show you their wounds?
That calls for hearsay.
I think the form of the question, I think you would have to explore before the court would even consider it as to how he knew. I'm going to sustain the objection as to that form of question.
Have you had persons who admitted in your presence that they were using heroin show you their wounds?
Objection calls for hearsay.
Okay,
Declaration against penal interest.
overruled.
I have had people tell me they were dope addicts or dope fiends and told me where they fixed last recently, yesterday, before, etc.
And was there any similarity between the wounds that these people have showed you, the type of wounds and the wounds that you observed in the photographs there?
Oh, definitely, yes, sir.
Have you had occasion to observe persons personally known to you as heroin addicts inject heroin into their system in your presence?
I've been in an undercover capacity by a controlled substance and watched a guy fix or inject controlled substances in his system. I've also, if I can go on,
Could you describe the manner in which it was injected?
he was holding it in his arm and putting it in his vein after he tied it off.
And was there any similarity in the appearance of this person's wound and the wounds in the photograph?
Yes, sir, there was.
In what respect?
Well, when you if I might explain, when you self-inject yourself,
No, we are getting into a little lecture.
The question was, what was the similarity?
the similarity, what I saw, neither one had a scab formation. It appeared very fresh in nature.
Object. That's a super conclusion.
What do you mean by fresh?
Yes, I'm going to have to strike the last answer. Ask the witness to describe. I don't. Fresh is a vague term. If the witness would describe it.
Okay, from what I've seen, when a person recently administers a controlled substance in a system, specifically a narcotic or heroin, the wound itself is raised. It leaves what's described as a volcano or crater-shaped wound. There may or may not be fluid leakage depending on how recent the wound was administered, and it usually does cause some discoloration.
Wait, I would ask it be stricken. All of that was generalization drawn from observations.
What?
And to make that type of a leap, this hearing is becoming a farce in my opinion, because this man is testifying just like an expert without having an opportunity to attack his expertise.
Excuse me, Mr. Scheckman, I take it you're making an objection.
Yes, I did. I asked it be stricken.
Would you let the court rule on it before you get into the argument? I am going to strike that last answer. It's non-responsive to the question.
Could you specifically relate in your detail in your personal observation of the condition of the wound, self-injected wound, in the case you just described?
They appeared the same.
Did you advise the defendant of his rights according to Miranda?
Yes, I did,
How did you do this?
verbally.
What did you advise him of?
I advised him he had a right to remain silent. If he gave up the right to remain silent, anything he said could be used against him in a court of law. That he had a right to counsel. He had a right to have counsel present with him while he was being questioned. If he could not afford to hire counsel, an attorney would be appointed to represent him before questioning, and he also at any time had a right to refuse to make any statements or say anything that might intend to incriminate him.
Did he appear to understand it?
I asked him if he did, and he said yes.
And what did you say next?
I told him I wanted to discuss narcotic usage with him, and he didn't want to discuss it. Well, wait, can I refer to my notes? It's been a while.
To refresh your memory, is that the report made by you?
This report was made by me. I take it back. He stated after he waived his rights that he had used heroin approximately a week before the contact in the Stockton area.
Thank you. What did you say next to the defendant?
Well, I told him, in my opinion,
Objection. I suppose that this is admissible. It might be admissible, but it's certainly not admissible for the truth.
No, let's hear the question, what his answer is.
Just what?
I just wonder if non-expert confronting a citizen with an opinion is a coercive tactic.
I don't know. Are you making an objection?
Let's see what happens.
Did you advise the defendant of your intent?
Excuse me, the question was, what happened next?
Oh, what happened next?
I advised him about a urine test that if he wished to give, whether or not he discussed whether or not he wished to give one, I told him that it would prove the presence of controlled substance in his system, as well as proving that it was there, and told him also it would show him innocent as well as show him guilty. I went into detail. We talked about it for a minute, and he decided he didn't want to give a test.
Do you appear to understand the nature of the test and what it would show?
Oh, yes, sir.
I'm going to ask it be stricken as irrelevant. I don't see what the fact that he chose to exercise his right as an American citizen to be free from search and seizure, what relevancy that has to his being committed an offense or not.
Consciousness of guilt, Your Honor.
You can't draw that from an assertion of a constitutional right. You can only draw it from something that would be inconsistent with a legitimate assertion of right. The fact, for example, that the police officers comes up to your door, and as they always do now that Raymond has been passed, Raymond decision has come down, ask if they can come into your house and search it, and a person says, no, you can't come into my house and search it. It is not consciousness of guilt at all. It is consciousness of citizen of rights that hundreds of thousands of people have died to protect. The identical rights. This is a search and seizure right. The police department doesn't have a right to go around searching the inside of your body or your bodily fluids, and the assertion of that right to take the assertion of a constitutional right and to use that against a citizen as consciousness of guilt destroys the value of the right. How would you risk asserting a right when a government attorney is going to come in and say the reason that he did that is because he was guilty?
That applies to motor vehicle tests.
Next question.
Does that apply to motor vehicle control tests?
Does that apply to motor vehicle control tests?
Your argument.
Well, I really don't think that that's an implied consent exception in narcotics cases. I mean, it's difficult for me to understand how the implied consent ever made it through the constitutional mill. That's always bothered me, but at least there was some legislative intent to go by. And of course, there is none here. There's nothing about that. You're arrested. You're implied to have consented to give urine tests.
Mr. Wall, did you wish to speak to Mr. Schuckman's objection?
I lost him in the train of extraneous argument, Your Honor.
His objection is the fact that the defendant was offered the test and refused and did not take it is inadmissible because of his right under the Fifth Amendment as far as self-incrimination is concerned. Did you wish to speak to that?
Yes.
Actually, it's not self-incrimination so much as the search and seizure, but it could be considered as either 4th, 5th, or 6th Amendment issue.
When the defendant was validly arrested for drug use, the defendant was exhibited certain indicia, what appeared to be consistent with being under the influence of heroin. I think an argument can be made, and I think looking at Schmerber and some of the cases analogous to the drunk driving cases, even a person who had a case to appeal here, Brian Hearn, just lately, where a person was unconscious, but he was a suspect, and even prior to arresting him, a blood sample was withdrawn from him, and obviously he had no right to. He certainly didn't have a chance to assert an implied consent or anything like that. I feel that the testimony bears out that there was no real coercion put on the defendant here, and that he could refuse it if he wanted to, and he did so. But I feel that knowing and being advised that this could also show his innocence as well as his guilt. The fact that he refused it, there is an inference, not a presumption or anything like that, but just an inference that the reason he did so was consciousness of guilt, and I feel this should be admissible.
I'd like to speak to that if he has finished. The courts of the Schmerber is an old case now, of course, and it's been interpreted down through the years, and it is clearly distinguished unconscious from conscious. The only question has become, what is conscious and what is unconscious? That is where the recent cases are. As a matter of fact, I just have a decision I got from the appellate division here in this county on that very issue. And there is no question if you're conscious and they want to start taking stuff out of your body, you have to consent to it because it is a search and seizure. Now, to the defendant or a person who is arrested is to be accused of crimes. It is an accusatory system, not to be interrogated and having it pulled out. That is the whole concept of Miranda and the whole concept of the American judicial system as far as law enforcement is concerned. And the assertion of a constitutional right becomes evidence of guilt. The constitutional right is gone. That's why silence in the face of questioning cannot be interpreted. It used to be the old common law rule. If you didn't say anything, you just decided you didn't want to play games with the government, and that is the interpretation should be put on this. Mr. Holloway has no objection to give any kind of test to prove anything. Maybe he thinks test procedures are inadequate and he doesn't want to risk it. We don't know what it is, but it is an assertion of a constitutional right. And if assertion of constitutional rights are going to be evidence of guilt, we might just as well tear it down.
I will take the motion to strike under submission at this
No
time.
further questions, Your Honor.
Mr. Schuckman, in view of the time, would you want to start at 1:30?
It's up to the court. I'm ready to go.
I'll give you 5 or 10 minutes.
Fine. I really don't have that many questions if we are not going to have him as an expert witness.
Fine.
Officer, on occasions when you do form an opinion with respect to whether a person is under the influence of heroin, do you do that on the basis of comparing your observations of that person with your observations of other people that you personally knew were under the influence?
If I understand your question correctly, you're asking me if what I base my, what you called opinion on.
Not in this case. In other cases, when you do form an opinion, do you base it on any other factors that you've described here? Comparisons with supposedly known samples?
Well, it's a hard question to answer yes or no because there is a bunch of variables to take into consideration. Learning experience is vast and continuing. You base a decision or opinion, if you will, on what is put in your head from what you see and what you hear.
There is really no difference, is there, between saying that this person is under the influence? You're saying that, and you're saying that this person has all the characteristics
Objection, Your Honor.
which you have observed in other persons whom you personally knew to be under the influence. There's really no difference between these two, is there, in your mind?
Objection, this is beyond the scope of direct. It's trying to elicit an opinion testimony when none was given.
I will allow him to answer the question. The objection is overruled.
It's a yes or no.
I have to say no.
It's not the same?
You want a yes or no answer? All I can say is no. If you want me to explain the answer, I can.
Sure, go ahead.
When you reach an opinion or make a formulation in your mind, if you will, that somebody is doing something, this could be based upon, you can't say it's based upon A or B. It might be based upon a wide range of reasons.
All right.
But when I reach a decision, I try to take everything into consideration.
All right. You indicated that you saw that one of the comparisons that you were able to tell us about here was a comparison between the marks on Mr. Holloway's arm and the marks on the arm of the person you saw fix. Is that right?
That's correct.
Okay. Who was that person?
His name?
Yeah, his name. Who was he?
Just a second, I'll try to think. It was a case in San Leandro. Kuhl. Kuhl.
And did you make a report of those observations at that time?
Myself personally? No, I did not.
Did you participate in the making of a report?
The gentleman I was with made the report.
I see. Did you participate in the preparation, corroborate with him?
He made the report, corroboration. He might have asked me some questions and I answered him as far as what I've seen regarding the specific offense.
So there are records available with respect to the testimony you have given as to your observations?
Yes,
Here.
I believe there is, sir. They are not here, though.
I'm going to ask once again. I know that we are at the situation we often arrive at where we have made an extensive discovery motion as we can. We have in fact received specific orders for discovery directed to the police department for all records that are reasonably available to them relating to the type of testimony that's going to be given at the trial. So he comes in here and says, oh yes, I'm not the expert, but I observed a fellow named Kuhl, or whatever his name is, down in San Leandro who had injected in my presence and had similar marks. Where's the report?
Okay, I'm not too sure what your motion is.
First motion.
Stop. Whew. That was a marathon. 19 minutes almost. Okay, we're gonna do 2 minutes of warm up and then we'll do a take. 2 more minutes here. Just to get you writing something else.
Just trying to get a tick on my throat.
Take one, pass it down.
I'm sorry.
So I'm gonna do the first 2 minutes, I'm gonna guess here. Yes, we are. I am Mr. Kozina for the plaintiff.
I'm the witness.
I am the court.
I am attorney for defense, Mr. Somera.
Let's read this in 14s. Mr. Kozina begins. On the record. Okay,
And my dad, too. They were all trying to get me to go to rehab that day. Even the cops and my dad had him.
did your dad arrive before the police arrived?
And my brother also. They were all, my whole family was trying to get me to go to rehab.
Are you on any medication today?
No, I'm 100% sober.
You're always speaking this quickly.
I'm a very fast talker, yes. Actually, I did a study online and people who are really smart actually talk really fast.
All right, thank you.
So you called your father from your neighbor's phone?
From my neighbor's phone, yes.
Was this before or after she called the police?
This was before she called the police. I called my father to come unlock the door for me.
Did your father then arrive before the police came, or did he arrive after the police came?
After, but my cousin came there before the police because he lives around the corner and he also has a key. So he made it to my house and unlocked the door for me before my dad, because my dad called my cousin to come unlock the door for me.
Okay, and you said you lied to the police officers when you spoke to them that night.
Yes,
Did you lie to them when you said that the defendant had been harassing you all week, peeping into your windows and sending you text messages that he was going to kill you?
everything but the text messages.
So he had sent you text messages?
Yes, he did.
Did those text messages threaten to kill you?
Yes.
How soon before this night were you receiving those text messages, if you recall?
Repeat that question, please.
How close to this night did you receive those text messages?
I have no idea.
Did you lie when you said that the defendant forcibly broke into your bedroom?
Yes, I did.
Did you lie when you said the defendant pried off the screen and slid the window the rest of the way open?
Yes, I did.
Did you lie when you said that the defendant then held you a captive and tried to convince you to take him back for 1.5 hours?
Yes, I did.
Did you lie when you said that he then became physical with you because you wouldn't take him back?
Yes, I did.
Did you lie when you said he said, "I'm going to kill you, bitch"?
Yes, I did.
Okay, that was 2 minutes. I'm gonna pause this recording because now we're gonna do takes, so
Sorry.
don't go away. I'm gonna restart, and we'll do the takes.